morning and welcome to the June 23rd, 2025 Land Use Hearing Officer meeting. I'm Pamela Jo Hatley. I'll be serving as your Land Use Hearing Officer this morning. Before we get started with the agenda, please stand as you're able for the Pledge of Allegiance. All right, thank you. Again, I'm Pamela Jo Hatley. I'll be serving as your Land Use Hearing Officer this morning. Before we proceed, Ms. Marshall, are you ready to introduce staff and agenda changes?
Sure, I can do
okay.
that.
This is Colleen Marshall with the Development Services Department. We'll introduce staff and agenda changes first.
Morning, Colleen Marshall, Development Services. To my left is Mary Dorman of the Hillsborough County County Attorney's Office. Carmen Mason of Development Services staff will be joining us virtually today. During the course of the hearing, a number of other staff planners will be presenting their findings for various cases and will be introduced for each item. We have no changes to the published agenda.
Thank you, Ms. Marshall. All right, the agenda this morning consists of items that require a public hearing before a hearing master. I'll conduct a hearing on each item today and will submit a decision within 15 working days after the conclusion of today's hearings. My decisions will be filed with the Clerk of the Board of County Commissioners. The hearings today will be informal. I will ask questions related to the scope of direct testimony and may call and question witnesses as I deem appropriate. I will decide all questions of procedure. I will take evidence, but will exclude evidence that is immaterial, irrelevant, or unduly repetitious. Evidence may be presented in written form, and all testimony shall be under oath. Hearsay evidence may be used to supplement or explain other evidence, but shall not be sufficient alone to support a finding of fact unless it would be admissible over objections in a civil court action. The order of presentation today shall be as follows. First of all, for variances, Ms. Marshall will call the case. County Development Services will have 5 minutes to present its report and findings. The applicant and the applicant's witnesses will have 15 minutes to present the proposal. Proponents will have 15 minutes to present arguments in support of the proposal. Opponents will have 15 minutes to present arguments against the proposal. Then county staff will have 5 minutes to present any amended findings or comments, and the applicant will have 5 minutes for rebuttal and summation. For special use cases, Ms. Marshall will call the case. The applicant and the applicant's witnesses will have 15 minutes to present the proposal. County Development Services will have 5 minutes to present its report and findings. Planning Commission, if applicable, will have 5 minutes to present its finding of compliance or non-compliance with a comprehensive plan. Proponents will have 15 minutes to present arguments in support of the proposal. Opponents will have 15 minutes to present arguments against the proposal. And county staff will have 5 minutes to present any amended findings or comments, and the applicant will have 5 minutes for rebuttal and summation. The 15 minutes for proponents and opponents is the total time allotted among them. So if there are a number of persons who wish to speak, the 15 minutes will be distributed among those speakers. Also, if there are a number of persons who wish to speak on an item, you may designate a single spokesperson to represent your views. When you come to the microphone today, please first state your name and address for the record. The meeting is being recorded, so please speak into the microphone so your testimony can be recorded. When you're finished speaking, see the clerk to my left to sign in for the record. Also, if you have any items on you today that make noise, any noise-making items, please silence those at this time. And now we'll hear from the County Attorney's Office on the legal requirements for appeals of the Land Use Hearing Officer's decisions.
Good morning, Mary Dorman from the County Attorney's Office. This Land Use Hearing Officer public hearing is for variance and special use requests. This is the time for interested parties to present evidence and testimony. Once the Land Use Hearing Officer has closed a case, the record of that case is also closed, and no new evidence regarding that case may be submitted thereafter. Any decisions by the Land Use Hearing Officer may be appealed to the Land Use Appeals Board. Should a decision of the Land Use Hearing Officer be appealed, the record evidence, including the testimony presented at this public hearing, shall be the only evidence that is subject to review by the Land Use Appeals Board. In reaching a final decision on petitions, the Land Use Appeals Board will only consider the decision of the Land Use Hearing Officer and the record evidence, including any evidence from this public hearing. If an appeal is filed, the Land Use Appeals Board hearing shall consist of oral argument by the party appealing the decision, county staff, and any interveners, each of whom may be represented by legal counsel. The following shall have standing to appeal a decision of the Land Use Hearing Officer or to intervene in an appeal. 1, the applicant, or 2, anyone who appeared before the Land Use Hearing Officer, presented testimony or other evidence, and is adversely affected by the decision of the Land Use Hearing Officer. It is the role of the County Attorney's Office to ensure that no new evidence or testimony is allowed before the Land Use Appeals Board that was not presented to the Land Use Hearing Officer at today's hearing. The County Attorney will recommend that the Land Use Appeals Board disregard evidence or testimony that is outside the record made at today's public hearing. Any evidence presented to the Land Use Appeals Board that is outside the record created at today's hearing could jeopardize the legality of the Land Use Appeals Board decision, and the presenter of that evidence could hurt their own cause. The safest course of action, then, is for you to write down any comments you make today and repeat them to the Land Use Appeals Board.
All right, thank you. Again, all testimony taken today shall be under oath, so if you do plan to speak, please stand and raise your hand to be sworn in. If there are any online who plan to speak today, please also raise your hand to be sworn in. All right. Do you swear or affirm the testimony you are about to give is the truth, the whole truth, and nothing but the truth? Thank you. All right, Ms. Marshall, we're ready for the first case.
Today's agenda, we have no vested rights, fee waivers, remands, or reconsideration requests, which brings us to Section F, Site Development Variance Request. Item F1, Variance 250796. The applicant is Little Harbor Investments, LLC. The request is a variance to encroach into the wetland setback. Staff findings will be presented by Ryan Joyce.
All right, applicant. Actually, Development Services first, right? Applicant, we're going to hear from Development Services first.
He is Development Services.
He is Development Services. I'm sorry, thank you. New one on me today.
Hi, Ryan Joyce with Development Services, Natural Resources. The applicant is requesting a variance from the 50-foot wetland preservation area setback requirement, Section 4.01.07.b.4 of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on 05/06/2025, is to allow for encroachment for asphalt, concrete, pool equipment, fence, and a retaining wall to be within the 50-foot wetland preservation area setback. Section 4.01.07.b4 of the Land Development Code, the requirement is no filling, excavating, or placement of permanent structures or impervious surfaces shall be allowed within the required 50-foot setback, wetland preservation area setback. Their specific variance request was 50-foot max encroachment for asphalt, concrete, pool equipment, fence, and a retaining wall in the wetland preservation area setback, resulting in a 0-foot remaining setback. With our findings, the wetland setback compensation planting plan provided on the site plans dated 05/06/2025 will be reviewed through commercial review during the site construction intake process. That is all.
Thank you very much. All right, applicant now.
Good morning. I'm Dylan Reeves. I live at 935 11th Street North, St. Petersburg, Florida. I work for Biotech Consulting. I'm the environmental consultant for this site. I believe I submitted a PowerPoint that we could go over. Has that been uploaded or?
I'm not aware. Staff or technical staff Is there a PowerPoint?
No, they said to email it so they could have it prepped and ready to go. I do have copies of the PowerPoint if I can, it's exactly what it was, if I can give that to you.
Put it on the Elmo there.
Thank you. They can be placed on the overhead. We'll give you a minute to do that.
Yeah. Show me what I need to do.
You just put it down just like you read. So you just put it right down there.
All right.
Face out.
Okay. We'll put this out. This is just to show the variants that we're discussing. I want to get you familiar with the site location. That's a location map. It's in Ruskin, Florida, very close to the bay. This is, I'm just getting you familiar with the site and what it is right now. So this shows, yes, you're welcome. This shows the parcel, which is a conglomerate of 4 parcels. My finger here, and you'll see it better in here, is right there. There's 1, 2, 3, 4 parcels in there, which make up the Little Harbor Parcel P, which is in the South Bay CDD. This is a 4.85 acre site. There you can see the boundary in red that goes around the parcel. I'm going to give you a little bit of parcel history here. Some historical aerials. You can see in 1938 there was nothing developed here. Let me move back. There's one thing that's important to know on the parcel map. You can see that all the parcels that make up Parcel P, these 4 parcels right here. There is a parcel to the south of there, which is owned by the South Bay CDD as well, which is, and you'll see it, which is really is a man-made canal, is what it comes down to. So I showed you the 38 where there was nothing. Here's the 57, which you can see on the south side of this parcel, that canal being there, as well as it heading off to the west.
Okay, and just to be clear, that parcel that you pointed to, that is the canal parcel, it is owned by the same owners, the applicant,
Correct.
but it is not part of this, the parcel that's being requested for the variance, correct?
Yeah, that's correct. I mean, the ownership of the master site, the CDD, is South Bay Holdings CDD.
Okay.
The applicant here is Little Harbor Parcel P, so this
Okay.
is a part of it.
And the wetland area includes that canal area?
That's correct.
Okay.
Because EPC would anything that's even surface waters are considered wetlands. And as you'll see today, it's filled in with mangroves and such not, but it really is just a man-made canal. And south of that, just for your knowledge, is ELAP lands, as well as east of that too.
Okay, thank you.
You can see in 84, you can still see the canals prominent. There's site development through, roads and things being developed. The whole basin has been developed. A lot of it's been hardened with seawalls, although this site was not hardened with seawalls. And just one more, that's 95. Seeing the same thing. You can still see the canal there, but it's starting to fill in with mangroves over top of the canal.
And is this, the subject property, is it all part of a bigger development, a unified?
Right, I didn't show the whole development, but it's a part that was the South Bay Holdings CDD site, which goes off. You can see the basins in this photo right here across the street. There's several large marina-style, docks within the development, some parcels north and to the west of this that are all part of a master development that was developed back in the, it looks to me through historical aerials back in the 60s.
All right, thank you.
So this is showing the parcel as it appears today. Yeah, thank you. I was going to stop talking so they could see. What you see there as the cross-hatched area is what the typical 50-foot buffer would be. You can also notice a little bit to the east and to the west, I have that drawn out, and I'm going to show you photos of that to show you that to stay consistent with adjacent development. This would not be inconsistent with the adjacent development, what we are proposing.
The vegetation along the south side of the parcel, is that mangroves that within the parcel?
Correct. It's mangroves, a small amount of Brazilian pepper, but it's mangroves leading down the side slope of the canal. It's not, they're not growing out of the bottom of the canal. They've just filled in enough to where their tops, come across the canal at this point. So this photo is the site adjacent to the east. Let me move this up a little bit. What you can see here is what a 50-foot buffer would look like on that site. And you can see in that site they have parking and ingress-egress infrastructure coming through that. What you can't see is if you zoom out on the whole development, this takes place and goes around and goes north, and it has a bunch of parcels within here who have the same conditions, which is development or open area that's been graded and maintained since the 60s all the way up to what would be the wetland line.
Do you know about when this parcel that you're showing was developed?
I do not. We may be able to see it in some historic aerials. It looks like in 95 it was not developed. So that parcel was developed after 1995. I'm going to show you the adjacent parcel to the west, just illustrating the same sort of 50-foot buffer, which has, in this one, it's not just parking and infrastructure, there's buildings. I assume those are multifamily apartment style or condo buildings. So I'm going to show you the site plan. Now, it's important to note that we purposely planned the buildings to be as far away from the southern boundary as possible. The green area is what we're here today to discuss, which is the request to impact that green area. Now, it's important to note that there are the wetland line runs right in here. It's the crosshatched area. There are small areas we can't see it in between the wetland line and that red southern line is going to be a retaining wall, where there is anywhere between 3 and 8 feet that is going to be planted. Additionally, this gray area in here is going to also be planted as a buffer. But what we're requesting is to be able to use this parking and egress here within the 50-foot buffer.
And the proposed seawall, which is not something I decide, it's not before me today, but just so help me understand the development here and the variance. Will the seawall extend all the way across the site, including that gray area?
Well, let me, a point of clarity. It's not a seawall, it's a retaining wall. We could come in and permit a seawall along the within the canal, the actual boundary, but that would eliminate us from having to have any kind of buffer requirement. What we're doing by putting in a retaining wall, and I'll get to additional measures we're doing with that retaining wall to help buffer the area, that retaining wall is outside of the wetland line, and the nature of the request is to come up as close as we can to use the area that we need to use for this site development.
Okay, and thank you for clarifying that. You said the retaining wall is outside the wetland line, so it's to the north of the wetland line within the parcel?
That's correct. So I don't know how well you can see, but let me follow it right here.
Just bring the microphone over a little bit, please. Thank you.
Sorry. Where my pen is, this is where the retaining wall will be. Comes all the way across here, right? So we're not directly impacting the wetland to construct a seawall. And if we were to do that, there would be a direct loss of mangrove habitat. We thought it was a better option to do a retaining wall and ask for a buffer requirement rather than permit a seawall and actually lose mangrove habitat to not have to provide a buffer. So I'm just going to show you cross sections. Can you zoom in on AA or BB right there for me, please? This is just showing you the cross section where we're going to have the retaining wall outside of the wetland line. Then on top of that wall, which is nothing that any agency has required, we're going to put a 6-foot-high opaque fence to help buffer. You know, we all know the reason for a buffer is to prevent light and noise from entering the wetland. No agency is requiring that, but we're trying to be good environmental stewards, and that 6-foot-high fence will help stop the light and the noise, as well as the buffer enhancements that we do throughout the site. Thank you. So parcel P is requesting a variance from the standard 50-foot wetland buffer requirement. As demonstrated in the prior slide, similar encroachments into the buffer have been approved and constructed on adjacent parcels and throughout the South Bay CDD. The requested variance seeks to maintain consistency with the existing development pattern where infrastructure, parking, and even building footprints are located within the buffer area. Granting this variance would ensure continuity in the site planning and land use while aligning with established precedent set by neighboring properties within the same community. A few other things to note. Parcel P, we're fully permitted with the Water Management District. And the permit number is 43047-907. We also have had a formal wetland line review with EPC, which shows that we are not having any direct wetland impacts. A part of our permitting with the Water Management District is, you know, they have direct wetland impacts. They also have secondary wetland impacts. When you don't directly impact a wetland, but you impact the buffer and allow light and noise to get into the thing. We have, because of the 30-foot buffer encroachment which is required for the Water Management District, we have provided mitigation already through the purchase of mangrove credit at the Mangrove Point Mitigation Bank. So we provided mitigation to the state for the light and noise intrusion. Additional measures that we've taken on the site is, although not required by any agency, we're adding that opaque fence on top of the retaining wall that we were discussing. As shown in the adjacent buffer enhancement detail right here, the upland areas that are going to remain as buffer in post-development will be planted with Florida native vegetation. As it is today, there's no vegetation there. It's just a manicured open space. And lastly, to wrap up my presentation, the variance is being requested because parcel P, as currently configured, cannot practically accommodate the full 50-foot wetland buffer. Existing site constraints. The parcel's shape, topography, and existing improvements forces a buffer encroachment area into proposed improvements, effectively precluding reasonable development. Consistency with surrounding parcels. Adjacent lots already have reduced wetland buffers less than 50 feet, and a blanket 50-foot requirement here will create an inconsistency pattern of encroachments across the neighborhood. Avoidance of undue hardship. Imposing the full buffer on parcel P would leave no viable area for the intended improvements, while aligning its buffer with its neighbors preserves both the wetlands function, protection, and allows for reasonable use of the land. And that's what I have.
All right, thank you. And what are the intended improvements?
The intended improvements will be roads, or ingress, egress, and parking, essentially. There may be a pool. How do I zoom in on this?
And this serves, the buildings are residences?
Yes, it's a multifamily project. And we put the buildings as far away from the wetland as we could because they're going to sit up taller.
All right. All right. I have no more questions for you. Thank you.
Thank you.
And be sure and sign in with the clerk.
Where do I sign in?
All right. Is there anyone here or online who wishes to speak in support of this application? All right. I do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right. Please come forward if you wish to speak. Thank you. State your name and address first.
Good morning. My name is Sean Storch, 1022 Seagrape Drive. I live in the neighborhood just to the north and east of the proposed project as shown on the overheads. I am opposed to this project. Our neighborhood is very environmental as far as you've got manatees. There is wintering grounds there right on that parcel for American bald eagles. It's a nursery for osprey. We have wintering grounds for the South American swallowtail kite. The canal that was mentioned actually flows directly from that property. There's a bigger canal under the bridge where they proposed the egress that flows right into Tampa Bay. And the threatened manatees do breed in that area. We actually saw them there the other day. He mentioned that the fencing will preclude light and sound. Unfortunately, the parking coming closer to the wetlands area, they've mentioned nothing about how to handle the hydrocarbon load coming from all the additional parking space in that area. So, again, just opposed. That's all I have. Thank you.
All right, and may I ask, sir,
Sure.
Do you have credentials as a environmental scientist or a
I have a
engineering?
degree in biology, but that's about it.
Okay, all right. Thank you very much. I appreciate your testimony. All right, County Development Services, anything further?
Nothing further. Thank you.
All right. Just a second, I saw someone stand up in the back. Was there another speaker in opposition? Okay, that's a no. All right, thank you. Applicant rebuttal. And would you address, I guess I have sort of a lingering question about the hardships. And I do understand your point about the development on the adjacent parcels. And I do understand you did make the point that reasonable development couldn't be accommodated without the variance. And so I understand that point. Can any development on this parcel be accommodated, I guess I should say any reasonable development on this parcel be accommodated without the variance?
I don't think so. I think with the value of land these days and the intended use of the South Bay CDD, which was to promote condos, marinas, and multifamily, these aren't single-family lots, living. At this point, if you were to build something with a much smaller footprint, because all it is really is parking that we have in there. And you need so much parking, as we all know, when you have so many units. If we were to reduce the units to something to be able to reduce the parking to move this out of that, it just simply would not work with the finances of the site, is what it comes down to.
Okay, and parking couldn't be accommodated, for example, under the buildings or something like that?
Not that I'm aware of. I'm not an engineer. I don't know that, but I would think that was an option that they explored.
All right, and your, I guess a question about the canal, because the opposition speaker mentioned there were manatees in it. How wide is that canal? Is it?
The canal is about, just from measuring off Google Earth, about 25 to 30 feet wide. It is, I guess a manatee could get in there under the mangroves. I don't see it as being a very viable manatee habitat. And I would also say that if we were to permit a seawall in that area, that would encroach closer into there. It's not a super deep canal, although it retains water all the time. And then to speak to his point about other listed species, there's no recorded eagle's nest within 660 feet, which is the eagle nest buffer of this site. There's not any likely eagle nesting areas because they like to nest in large, basically pine trees, but large trees. The only trees that this site has on it are cabbage palms. And if there were to be any listed species worries, it would be ground nesting birds, but there are ground nesting birds, potential nesting sites all throughout this development and all throughout this area.
The ELAP land on the south of the canal, it was hard to tell from the aerials, but is it open water or more sort of wet?
It's more like salt flat.
Okay.
Marine, and we worked for ELAP cleaning those up and removing exotic species for a few years. It's been a few years since I've been there, but it's one of those areas that comes in floods, in king tides, or it's really a flood control area, and then the water evaporates and you get left with salt flats, a bunch of black needle rush areas. There are some freshwater wetlands within this area, but which basically look like old karst features, but it's not fully wetland in there, but for the purpose of this, we can consider it fully wetland because the upland areas haven't been delineated.
Okay, thank you. Anything further you have for the record?
No, ma'am.
All right. I have no further questions for you.
Thank you.
So this will close the hearing on variance WS 25-0796.
This brings us to section G, sign variance request. Item G1, variance 250783. The applicant is Palm Harbor Dermatology, PA. The request is a variance to sign requirements. Staff findings will be provided by Michelle Montalbano.
Good morning, Michelle Montalbano, Development Services. The applicant is requesting a variance to accommodate a new pole sign utilizing the footer of an existing damaged sign. Per LDC Section 70300C1, all ground signs shall be set back a minimum of 10 feet from the public right-of-way line. The applicant is requesting a 10-foot variance, resulting in a pole sign with a 0-foot front setback to the Sheldon Road right-of-way line. The existing pole sign appears to overhang outside the property lines and into the public right-of-way area. Therefore, the applicant has reduced the size of the new sign cabinet, so the sign will be completely within their property boundaries. I'm available if you have any questions.
All right, thank you. No questions for you. All right, applicant?
Good morning. My name is James Ullery. I am with LED Tampa, 2170 Sunnydale Boulevard, Suite U, Clearwater, Florida. And we are the company that is proposing the manufacturing of the new sign and resolving the issue with the setback. And I also want to introduce Austin Chapman.
Hello, Austin Chapman, 5200 Burlington Avenue, representing Ross Real Estate, the owner of the property and the business itself, Palm Harbor Dermatology.
Thank you.
Thank you. I would like to put something on the overhead. Thank you, sir.
Okay.
We are requesting a variance for the setback, and I will explain to you why we are requesting and explain the hardship. So the existing sign, if we can see right here, due to the storms, the identification faces in this sign, which are Palm Harbor Dermatology, these faces were blown out last fall, like many signs were. So currently this sign, this structure is still sitting there without an ID face. We met with the customer, and the ask and the desire for the customer was to build a new sign and not use this old sign because obviously the faces blew out. It's an old sign and it just does not have proper technology. So the new sign that we are proposing is to the right. This sign is smaller. We went from a 72 square foot sign to a 48 square foot sign. And it's manufactured of new technology, so we stand a lot less chance of having another storm blow out the identification faces. So in doing our permit and research work, we discovered that the new ordinance which comes into effect when we do a structural modification, which putting a new sign on the pole is considered a structural modification, that the setback from the leading edge of the sign from the property line should be 10 feet. Well, unfortunately, and I'm going to show another picture. So on the top, we show the property line and we show the existing sign structure. So it's pretty obvious that the actual sign structure itself overhangs the property line into the right-of-way. When we look below, the new sign, which is smaller, does not overhang the right-of-way. However, it does not meet the requirement of being set back 10 feet from the property line. So now, if we look at the hardship, this is a multiple factor hardship. Number one, in order to meet the code, we would have to create a new sign footer. And when we create a new sign footer, that footer is going to be placed into the parking area, which is going to cause the elimination of at least one parking place. And number two, it's going to create a sizable amount of expense and discomfort to the property, to the people that are going to the Palm Harbor dermatology. So in speaking with staff, and trying to come up with what solutions there were, the recommendation was made that we apply for a variance to the sign setback. So there's not a whole lot more to talk about. There is no issues with the property or the property surrounding. It just allows us to use the existing sign footer, which is in place, install a smaller sign, which accomplishes the needs solves the customer's issues, prevents construction.
Do you know where the sign footer, how far away from the right-of-way is it?
It's set back from the right-of-way approximately 10 inches to a foot from the right-of-way. Because we actually took the property plan, the plot plan that was obtained, and we looked at it, and I mean, there's not a specific line drawn in the sand right there, but it appears to be set back from the right-of-way.
Okay, and when I say footer, this may not be the correct terminology, but the actual pole that the sign is on, it's set back about a foot from the right-of-way?
Yes, ma'am, it is set back from the right-of-way.
Okay, but just about a foot?
At least, because the pole sits right in the middle of the of the footer. So that footer is 3 feet wide.
Oh.
So it's probably more like 2 feet back.
Okay. Is there any other location on this property where the sign could be placed that it could meet the setback?
No, not without infringing and requiring the removal of a parking place. We walked the facility, looked at the facility, looked at the plot plans of the facility. There is only one other place where you could possibly move a sign, but it would put it in a median, which we would then have people driving past the median parking place, with a sign footer there, and staff and I both said that that would cause more harm than it would do any good.
Okay, so for example, like just above where the sign is, that little, I guess it's a median or like a parking island that juts out, it couldn't go in there, is that correct?
It could, but that area is so narrow that then I think we would be causing traffic hazards, or with people driving their cars in, having that sign right there in that median area.
Okay.
So this is a very logical solution. Palm Harbor Dermatology, they could, within the code, they could just put new faces in that existing sign and it would sit right where it is. But now we still have a very large sign. We haven't really accomplished or solved any problems there. The goal was to reduce the size of the sign and put a new structure up that was much safer for the environment.
Okay, thank you. I have no more questions for you. Did you have anything else to add?
Yes, Austin Chapman, who is a representative of Palm Harbor Dermatology, I believe would like to make a statement.
Thank you.
Well, I appreciate you taking the time to review this. What we're looking at is just building the existing sign on the footer. We're trying not to take away any of the parking spaces because we're already borrowing parking from the business across the street. And I believe the Hillsborough Code is very strict on parking spaces, and we already don't have enough. So even if we were to place it on the little jut out there, I think we'd still be eliminating one parking space, so that way we're not taking damage on vehicles and having to pay that liability out. I appreciate it.
All right, thank you, sir. I understand. No more questions for you. Be sure and sign in with the clerk.
Thank you.
Thank you. All right, is there anyone here or online who wishes to speak in support of this application? All right, I do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? Do not hear anyone. County Development Services, anything further?
Nothing further. Thank you.
Okay. Applicant, did you have anything further? All right, that's a no. That's fine. Okay. Applicant says no. All right, this will close the hearing on variance 25-0783.
This brings us to section H, variance request. Item H1, variance 250589. The applicant is Anthony Gonzalez. The request is a variance to lot development standards. Staff findings will be presented by Orlando Boras.
Good morning. This
Good
is Orlando.
morning. Go ahead, Orlando.
All right, there's a person online. We're going to hear from staff in the room first. Thank you.
Good morning. This is Orlando Borras with Development Services. As it was mentioned already, the applicant is requesting a variance for lot development standards. The applicant also submitted plans for review back in December 2024. And upon staff review, it was found that the applicant was not meeting the minimum front setback requirements. Therefore, today the applicant is requesting a variance to reduce the 30 feet requirement in the CG zoning district to 15 feet, just to accommodate a soccer field in the property. I don't know if you have any questions, but more than happy to answer them.
All right, thank you. I have no questions.
Thank you.
All right, applicant.
Hi, good morning. My name is Anthony Gonzalez, owner of Play 5. We are a mini soccer, small-sided, five-a-side.
Can I get your
pitches.
address for the record, please?
Mr. Gonzalez,
Yes.
please state your address. Thank you.
Sorry about that. It's 7703 Madison Avenue, Tampa, Florida, 33619.
All right, thank you. Please go ahead.
Okay, so the proposed project is to construct small-sided soccer fields.
I'm sorry, I'm going to have to interrupt you one more time. Do we have your visual? Do you have your video on?
Yes, Sean Jamie, my engineer, is able to provide that. He is online as well.
I'm not seeing it.
Sean?
Anthony, they're asking for you to share your video on your camera or whatever device you're on.
I'm here.
All right,
You got it.
now we can see you. Please go ahead.
Okay, sorry about that. Okay, so it's to construct small-sided soccer fields, 5-a-side. The width of each field is to be 60 by 100, but right now it's cutting it down to 50 by 100 because of the 30-foot variance setback. So in order for us to get the maximum amount of field width so that the kids can play on, we need 60 feet, and that would be that 15-foot setback that we're asking for, instead of the 30 that you guys are requiring us to remove.
All right, thank you. So is it your testimony then that you can't use the property, the subject property, for its intended use without the variance?
Correct. We don't have enough field space. And also there is the adjacent Checkers site. If you do put the fields, like if we don't get the setback approved with that 30 feet with the parking lot of the Checkers next door, like if we build the fields too far, it's not gonna look aesthetically clean. Like when you ingress and egress of the plaza, the fields wouldn't be proportioned correctly when you're driving by. Like it's not gonna look good.
All right, do you have anything further to add for the record?
No, I do not.
All right, thank you. Then we will go to the public. All right, is there anyone here or online who wishes to speak in support of this application? All right, I do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, do not hear anyone. Development Services, anything further?
Nothing further. Thank you.
All right, and back to you, Mr. Gonzalez. Do you have anything further that you wish to add for the record? I'm sorry, I can't hear you now. Is your audio turned off? There we
I'm
go.
sorry about that. I had it
Okay.
on mute.
Okay.
Yeah, this is a small-sided soccer field. Intended use is, to bring, the community together through sport, and been in the area for 20 years and played college soccer, semi-pro, and coached in the area. So I just, trying to do this to give back to the community and for the kids.
All right. Thank you. Then this will close the hearing on variance 25-0589.
Thank you. Have a great day.
Next item is item H2, variance 250635. The applicant is Juan Madrid. The request is a variance to accessory structure requirements. Staff findings will be presented by Logan McCaig.
Morning, Logan McCaig, Development Services, variance 250635. The applicant is requesting a variance to side yard setbacks for an existing accessory structure over 15 feet in height. Per LDC section 61104, accessory structures over 15 feet in height shall meet the primary structure setback for the district. Per section 60101, side yard setback of 7.5 feet is required in the RSC 4 zoning district. The applicant is requesting a 2.6-foot variance, resulting in a 4.9-foot side yard setback to the north. During review, it was found that the property has received citation from Building and Construction Services for failure to obtain permits for the construction of the accessory structure. The structure also has a building permit in review, but it cannot be approved due to the side yard setback requirement.
All right, thank you. No questions for you. All right, applicant?
Hi there. My name is Juan Madrid at 1605 Whitehurst Road, and this is my wife.
Sylvia Madrid, 1605 Whitehurst Road. Sylvia Madrid, 1605 Whitehurst Road, Plant City.
Thank you. Go ahead and tell me what you're requesting and why you're requesting the variance, and what are the hardships associated with the property.
Because we have it at 15.6, I think the height of it, just For me to be able to bring it back down, I'll pretty much have to remove the whole roof and bring everything back down. I do have some pictures of the building.
All right. Mr. Madrid, did you construct this building?
Yes, ma'am.
And when did you construct it?
I started whenever COVID kind of hit, so that was part of my issue where I went to the court in Plant City, tried to get some permits and everything. Everything was being online at that point. Just kept having a hard time with it. That was my mistake of proceeding with it. So it took me 2 years to finish it because I was like working on the weekends pretty much with it, and I would change some stuff that I would have wanted to make sure everything was done right to what I wanted it to be done with it. I just didn't, like I said, didn't go through with the permits and stuff like that.
And the use of this structure?
It's just for barbecue, for us to hang out on the weekends type of thing. I mean, it's not for, nobody lives there. Okay. It's just, like I said, it's just kind of for barbecues and hangouts on the weekend type of thing.
And I'm looking at your survey that is submitted in the record. Is there another area on the property where this structure could be located that would meet the setback requirement?
Yes, there's a lot of space. I would just have to bring everything down, just tear it pretty much apart and, and start all over. That would be my issue.
Okay. So it appears there's no hardship related to the property itself. It's just that you have the structure in place now and you would have to take it down and start all over. Is that correct?
Yes, ma'am. I would have to take everything down. And I talked to my neighbors because of the distance between the building and their fence. See if they were okay with it. They just didn't want to get involved with anything with the court. We did send letters out to all our neighbors. Nobody's told us anything about it, as far as I know. Like I said, it's just a building just to have a cookout. It has, we had 2 hurricanes already come through that area, and I mean, it's still there. Nothing's been affected.
All right, thank you. I don't think I have any more questions for you. Did Mrs. Madrid, did you wish to speak?
No, you said everything.
All right, all right. Did you have anything further you wish to add for the record?
I guess I could show you some of the pictures on the, if I would have to, which is not just that. I would have to.
Okay, you're looking at your telephone, your phone. It looks like. Are you going to put them in the record?
If I could just show you a picture of the inside where I would have to pretty much take it all apart, if anything.
Okay, if you're not going to submit them for the record.
Oh, okay. I'm sorry.
Then
Okay.
you can describe it to me.
So I do have like an island bar. I do have, it does have tile. The inside, the top of it, it has all the plywood and everything surrounding it. It's been also pretty much the same way as the door. It has been torched. So that would pretty much have, if I would have to remove it, everything, the island bar, I have cabinets that I built and everything. So all that would, it's not just like an empty space in there. It's pretty much done to kind of what I wanted and stuff like that.
Thank you. Does it have electricity and plumbing?
Yeah, it does have plumbing. At this point, it does not have electricity because of the permits and everything. So I did stop everything. I do have, what I use is solar lights. That's what I have going with it. Like I said, I just use it for barbecue pretty much, just to hang out on the weekends, watch football games, stuff like that.
All right. Thank you very much. Is that all you have?
Yes, ma'am. Thank you.
All right, sir, be sure and sign in for the record.
Thank you.
Clerk here. All right, is there anyone here or online who wishes to speak in support of this application? I do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, I do not hear anyone. Development Services, anything further?
Nothing further. Thank you.
All right. Applicant, I'm just going to ask you quickly, did you have anything further you wish to add?
No, ma'am.
All right, thank you. This will close the hearing on variance 25-0635.
Next item is item H3, variance 250689. The applicant is BH Storage Riverview LLC. The request is a variance to dumpster and recycling collection space requirements. Staff findings will be presented by Sam Ball.
Good morning, Sam Ball of Development Services. The applicant is requesting a variance to allow for a single 12 by 12 foot dumpster enclosure to contain trash and recycling receptacles, where at least 2 12 by 12 receptacles or 1 12 by 24 foot receptacle is required. LDC 60315B, dumpster and recycling collection space requirements, requires enclosures for each solid waste or recycling dumpster container shall have a minimum internal dimension of 12 feet by 12 feet. They could also have one 12 by 24 foot enclosure. The dumpster enclosures are also required to meet the accessory structure requirements, but with major modification, PRS 25-234, it included a waiver to allow for a setback reduction from 50 feet to 8 feet. If this variance is approved, the applicant's request to reduce the number of required enclosures from 1 to 2 would result in one 12 by 12 foot enclosure to contain the trash and recycling receptacles. That concludes my report. If you have any questions.
All right, thank you. I don't have any questions for you.
Okay.
All right, applicant?
Hi, this is Jordan Ferralis with the applicant. My address is 2 North Tamiami Trail, Suite 104 in Sarasota, Florida. I'm here today to respectfully request a variance from the requirement for 2 separate 12-foot by 12-foot dumpster enclosures. We propose that a single 12-foot by 12-foot enclosure is entirely sufficient and appropriate for this specific self-storage facility. Our justification is rooted in the unique nature of this development. This self-storage facility will generate minimal waste and has a very low operational footprint, unlike typical commercial or multifamily developments. Our tenants are explicitly prohibited from using the dumpsters, so anytime they're moving in or out, it is not open to them for dumping their furniture or other belongings that they're storing.
I'm sorry, just a quick question. Is the enclosure kept locked so that
Yes,
can't
so
occur?
that's my next point here. They remain under lock and key, strictly for management use only. Additionally, our operations are 100% paperless, so all of our leasing and insurance documents are all done through DocuSign and are 100% electronic, so there's no paper waste or other waste. Additionally, customer visits post-move-in are very infrequent, which further reduce the on-site activity. Self-storage is also well documented as one of the least traffic-generating commercial uses. This low activity directly correlates to minimal waste output. Waste Management, who would service the site, has confirmed that a single 4-yard dumpster for solid waste and a single 4-yard dumpster for recycling are more than adequate for our needs. Each dumpster measures roughly 5 feet 10 inches wide and 4 feet 2 inches deep, which would easily fit the both of them within a single 12-foot by 12-foot enclosure and provide ample capacity for our infrequent collections. As far as site constraints and hardships, our site's highly constrained and environmentally sensitive, which demanded the efficient use of our land. We had to go through the zoning process for a major mod and minor mod before coming to you today with this variance request. We worked diligently with EPC to maximize the developable area while minimizing our wetland impacts. requiring an additional 12-foot by 12-foot enclosure would result in an unnecessary increase to our impervious area on a site where we're already trying to maximize developable space while being highly sensitive to wetland impacts. Adding more impervious surface is counterproductive to our environmental goals and official land use. In conclusion, this uniquely low waste generation, minimal operational footprint, and significant site constraints of this specific self-storage facility demonstrate that a single 12-foot by 12-foot enclosure is not only sufficient, but represents the most practical and environmentally sound solution. And we request respectfully your approval for this variance.
Okay, thank you. I have no questions for you.
Okay, thank you.
Be sure and sign in. All right, is there anyone here or online who wishes to speak in support of this application? All right, I do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, I do not hear anyone. Development Services, anything further?
Nothing further. Thank
All right. Applicant, did you have anything further? All right, that's a no from the applicant. This will close the hearing on variance 25-0689.
Next item is item H4, variance 250728. The applicant is Adonis Perez Sarmiento. The request is a variance to accessory structure requirements, and staff findings will be presented by Logan McCaig.
Morning, Logan McCaig, variance 250728. The applicant is requesting a variance to accessory structure setbacks for the purpose of constructing a garage on the property. Per section 61104C2, accessory structures shall be permitted in front yards at twice the depth of the required yard or 50 feet, whichever is less. Per section 60101, a 20-foot front yard setback is required for the RSC 9 zoning district. Therefore, a 40-foot front yard setback will be required for this accessory structure. A variance of 9.37 feet would be required, resulting in 30.63 feet. Per LEC 61104B, accessory structure shall not exceed 15 feet in height. Structure is over 15 feet in height for a variance of 1 foot. For 1 foot 4 and 11/15 inches, resulting in 16 foot 4 and 11/15 inches. During findings, the applicant did not specify the requested front yard setback distance in their variance requests. As such, staff utilized a scale survey provided by the applicant to obtain the proposed front yard setback for the accessory structure. Land Development Code provides 4 exceptions to the 15-foot height limitation for accessory structures in LDC section 61104B, where the accessory structure meets the primary structure setback in the district. The maximum height may be that of the district. Staff does not find that the variance to the height of the structure to be necessary, as the proposed structure meets the 5-foot side setbacks required by the RC 9 zoning district.
Okay, just a quick question for you. In the variance request, it says that a variance is being requested for the size of the structure because it's over 600 square feet. Is there a variance necessary for that?
Not unless they are encroaching on the side or rear yard setbacks. So due to the setback requirements of the zoning district, no, it should not be required.
Okay, so it says that it's an 810 square foot structure, so that's not an issue?
No.
Okay, and I guess just a quick question about the variance. It says 1 foot 4 and 11/15 inches, and it'll result in, okay, the height, okay, I see. Height is 16 feet. Okay, never mind. I think I just cleared that up in my own head.
No problem.
All right, so disregard that question. No more questions for you. Thank you.
No problem.
All right. Applicant, please.
Good morning.
Good morning.
I have a terrible connection here in this bunker, but I will try my best to apply for this. So if you can see.
Okay, I'm sorry,
my
sir.
site plan-
Mr. Perez, first of all, please
Yes, ma'am.
state your name and your address.
Oh, yes, of course. My name is Adonis Perez Sarmiento. The address is 2407 South 46th Street in Tampa Bay.
Thank you. Go ahead.
So I have the site plans. I guess I forget to put the encroachment on the front yard. So I'm requesting to encroach on the front yard for 30 feet instead of the 50 feet requirements. I don't have any more space on this area. Right, this connection here. Do you hear me?
Yeah, I can hear you. So just to be clear, you are requesting a variance of 9.37 feet, so you'll have, your structure will be set at a setback of 30.63 feet. Is that accurate?
Most likely, yes.
Okay. You agree with that?
So the encroachment will be in the front yard of my property.
All right, you're cutting out a little bit. Can you please restate what you just said?
Yeah, let me go outside and see if I get better. Bye, please.
All right, we'll wait just a minute on Mr. Perez.
Can you hear me better now?
Go ahead and we'll see.
Yes, so I'm sorry, I was inside this facility with early service. I'm outside now, so I say my encroachment is about 31 feet on my own front yard setback.
All right, thank you. And your structure is about 16 feet, 4 and 11/15 inches
That's correct.
in height. All right.
Yeah, I believe the requirements are 15 feet only, but this structure is for a boat, garage, enclosement, and it needs to be that high or my boat doesn't go to fit.
All right. And so is there any other location on your property where this structure could be placed that does not need the variance?
Negative. My property is small, and I need to encroach on my own setback, my own front yard setback in order to accomplish this mission.
All right, thank you. I have no more questions for you.
Thank you, ma'am.
All right, and we'll go to the public then. All right, is there anyone here or online who wishes to speak in support of this application? All right, I do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, do we have 3 speakers?
4.
All right, so there's 4?
4.
All right, so you have about 3.5 minutes apiece.
Sure. My name is Jennifer Godin. I live at 4511 24th Avenue South in Tampa. I am the northern neighbor to this property. I would like to oppose this request. First, based on the applicant's ongoing pattern of misrepresenting and noncompliance. This property was built in 2024, which he was asking for a variance at that point to build a single-family residence, and he was granted that variance. And he built a multifamily property, which he now runs as a commercial Airbnb. He does not live on the property, and it does not coincide with the rest of the neighborhood. And this garage, I do not think is required or necessary. There's no hardship. He already has 2 garages on the property. Now he's seeking to add yet another structure. which effectively just turns the property into a commercial short-term rental business in the middle of a residential neighborhood. So it's already impacting the quality of our life in our neighborhood, and with the increased traffic, the noise, and ultimately the loss of the community feel. So granting this variance would not only reward this dishonest behavior or the past dishonesty, but it sets a precedence that invites further abuse of the zoning process. So I would respectfully urge that the committee deny this request based on those key points, and just in general, I am the northern neighbor and I would not like to see a third garage on this property, which is a multifamily commercial business running on this property in our residential neighborhood.
All right, ma'am, just a question for you.
Sure.
You say it's a multifamily?
Yes.
How many units are in the house?
He has 2 units, and I have his original variance.
All right, be sure you're on the microphone. You can pull that microphone over towards you.
Sure. His original variance request to build this property was for a single family, and here is his submitted site or plans, which shows a single family, but he actually built a duplex, which does not go with the look and feel of the property. 2 units, A, B, they both have a garage, and just in general, it's an unsightly building.
So you're an adjacent neighbor, is that correct?
To the north, yes.
Okay. By your own observances of what you see at this property, do you see 2 separate, I guess, families or units or tenants? Do you see evidence of 2 different units in this
There
property?
are 2 units, and he promotes them on Airbnb. He has never lived there, and we have a consistent amount of Airbnb traffic that comes to the house, and they stay there for whatever amount of days there are.
All right, and you have seen this property?
I have seen it, yes.
No, let me finish my question.
Sure.
Have you seen this property advertised on Airbnb for 1 or 2 units there? Doesn't matter, but you've seen it advertised?
I personally haven't pursued renting it. I've never looked at it. I believe the other property owners in the neighborhood have seen the actual Airbnb listing, but if that's your question, I personally have not seen the Airbnb.
Yeah, that's my question. So you don't have any direct knowledge of any listing on Airbnb or Vrbo or some other vacation rental site?
I personally have not seen it.
Okay, thank you. Anything further?
Nope.
All right, thank you so much. Next speaker, please.
Bruce Weir, 2413 South 46th Street. First off, with what he's done, he's violated this county and everything with the zoning. This is a single-family zoning area. He turned around, he put this in under pretense of his home. I personally have went online and I saw his advertisement, for the Airbnb, both units. I talked to his first customer for the B unit, which was the catcher, a baseball player catcher for one of the major leagues. Real nice guy. He has removed live oak trees without a permit. I called the permitting department. Jackie said there was no permit. And he totally went around the mitigation. He put no money into the mitigation bank for what he destroyed the live oak trees. So he doesn't give a rat's tail about this county or anything, just whatever he wants to do and shove it down your throat.
Okay, and then just to be clear, questions for you. You have personal knowledge.
Yes.
You have seen this let me finish my question. You have seen this property advertised for vacation rental, is that correct?
Yes, ma'am.
Okay.
Now,
are you an adjacent property owner?
I'm just a couple doors down.
Okay.
Now, he's also rented it by the hour, too, is what it appears.
And what evidence do you have that, or how do you know that?
Physically seen a car there, a couple hours later, gone.
Okay.
Okay. It got in the neighborhood, we were going to oppose it, so he took that offline. He left his other stuff up that you can find, but he really took his whole advertisement and everything offline. But I got to see it before, just a few days before he removed it.
Okay.
Thank you.
Thank you, sir. Next speaker, please.
Good morning. I'm Terry Summers, 2406 South 46th Street. I'm the property directly east adjacent of that property. I would just like to confirm what Jennifer and Bruce have said. Pretty much Mr. Perez has come into the neighborhood, told us a bunch of falsehoods, made us believe this was a single-family dwelling that he might even live in himself. He's not used it for that. I have seen the Airbnb advertisements for it, and Bruce is correct. He took it offline probably about a month ago before this hearing was scheduled. And I think that was just an attempt to be under the radar what he's actually doing. And he has cut down live oaks. I don't know about any permitting or anything for that, but I've watched him drop live oaks straight into the middle of our street, a very large tree that I thought he was going to take down the whole power grid when he pulled it, when he cut that tree. Some of his activities that have been concerning to me was during the whole time when he was building this structure that's actually there now. His workers, he and his workers both would speed through our neighborhood. They had no concern for the local residents, their well-being or how we felt about things. Parking in our driveways, cutting us off in the street, basically closing off the whole street just so he can do what he wants to do. And then when you complain about it, you wind up with flat tires and handfuls of nails and screws thrown in your driveway, which I have no evidence that he did that, but it was very ironic that the day after I complained to one of his workers, I had 3 flat tires. So I believe the man's being dishonest. Jennifer's correct. He already has 2 garages on that parcel.
I have a question about that, please, sir.
Go ahead.
You personally have seen 2 other garages on the property?
There are 2 garages.
Where are they located?
They're directly underneath the unit. So they're A and B unit. Each one of them have a lower level. So it's a 2-story. The first level is just a garage. So each side has its own garage.
Okay, so each unit has a garage as part of the unit. It's not a
separate, no, it's not a detached garage.
So there are no detached?
No, there's no other detached structures over there, and quite frankly, he'd be kind of tight to get anything in there anyway. And Bruce was right. There was been no mitigation for, the runoff, and our whole neighborhood, about 95% of our neighborhood was flooded by Helene, and just more construction going on just causes more and more problems for the rest of us.
All right, thank you, sir.
Thank you.
All right, next speaker, please.
My name's Devin Pachuta. I live just east of him, the next door neighbor. I am 2409 South 46th Street. Just like all my other neighbors have said, that Mr. Perez has been an issue and a problem. And we've been having to deal with all his stuff. The man does not live there, nor has he ever since it's been opened up. And I frankly think that maybe y'all need to check the variance or whatever the house is. The house is totally a duplex. He has 2 garages. I don't know what he needs a 3rd one for other than he's going to build on it and probably rent it out too. And I've had bad dealings with him. A matter of fact, when he was tearing down the trees or cutting the trees down, he cut one of my oaks. I had a police report made, but I did not pull the report or anything like that.
Okay, where is your property in relation to the subject property?
Probably about 100 feet from his front door.
Okay.
So basically, I am east. I'm a little northeast.
All right, across the street?
No, adjacent.
Okay, all right.
I'm on the same side. You know, hey, I got evens and odds.
Okay.
I'm right next door to him, but on the same side.
All right, thank
Just
you.
so.
No speaking from the audience, please. I want to hear the person at the speaker stand. Thank you, sir.
All right, thank you.
Anything further?
I just think there's something going on over there that's not right. I think
Okay.
his plans and everything are totally different than what is showing that we see.
All right, thank you, sir. All right, do we have, clerk, is there more time left from the 15 minutes?
Yes, we have a minute and 22 seconds.
All right, sir, did you have something else? State your name, please.
Bruce Weir.
Okay.
I would like for y'all to get him on record stating that he's not doing what we know that he's doing.
Okay.
And can you bring this before the right people? The
Sir,
zoning is wrong and everything else. Code enforcement, apparently, they look the other way. I don't know what the situation is. It's like they have deaf ears.
All right, thank you. This is just a hearing on the variance for this accessory structure. That's all it is.
I
Thank you.
respect that.
All right, sir. All right, do we have any more speakers in opposition? All right, not hearing anyone. County Development Services, anything further?
Nothing further.
All right, so Mr. Perez, back to you. And you
Yes,
have
ma'am.
5 minutes for rebuttal and summation.
Yeah, it's simple. I'm in orders. I cannot live in my house, unfortunately. I'm here on the 349 group right now, as you can see on my back. Can you? This is the sign that I find. I'm in a military order. I cannot live in my house for now. So I find some friends of my dad church to protect the house and take care of it. So I'm being in and out in orders since I built the house. Unfortunately, because I've been in and out in orders, I have to find people to take care of the house. So currently there is a friend of my dad on the church that is taking care of the apartment. Do you hear me? Because this communication here is in and out and blinking. Do you hear me?
Yes. Well, did you ask a question or?
No, just if you hear me. So,
Yes, I can hear you fine.
Yes, I'm not leaving the house. I cannot live in the house while I'm in orders. So my daughter and my son, they are teenagers. I built this apartment specifically thinking about living with them, and they want their own independence. That's why it apparently be a duplex. However, even though if it's a duplex, it's my permanent residence. Therefore, I'm allowed to have a duplex. Everything is legal. Everything is on documents. I built the house all the way from the ground up. Yes, I cut some trees, but everything was mitigated on the plans. And the plans was reviewed by the Natural Resource Department, and they agree that there was no other mitigations than moving the palms away. So all that is been done by the book. And yes, the neighbors have opened a couple of complaints with them. Co-enforcement. I spoke with the co-enforcement department. I spoke with the manager, supervisors, and everything is being reviewed by the departments, and they agree that there is no violation found on the house or the property. So going back to the matter of this variance, and the garage is needed for a boat. I have a boat that is getting old. It's a 1989 Commodore Regal. It's tall boat, right now it's on another of my properties and is getting damages. So I want to put it on the garage, and I want to, fortunately, when I finish my duty here and possibly this month, I will establish my residence finally in Florida. I'm delightful to go back home.
All right, sir, thank you. Is there anything further you wish to add?
I wish my neighbors happy lives and beautiful things to them. Unfortunately, I guess they don't like me, but I like them. They're very good people. I'm sure they are.
All right, thank you very much. So this will close the hearing on variance 25-0728.
Thank you, Joel. Have a good day.
Next item is item H5, variance 250771. The applicant is Gerard T. Doris III. The request is a variance to distance separation requirements for a community residential home. Staff findings will be presented by Tanya Chapella.
Good morning, Tanya Chapella. The applicant is requesting a 757 feet variance to the community residential home distance separation to accommodate a type A community residential home on the subject property. This will be resulting in a 243-foot distance separation to an existing community residential home. And this variance is related to the Land Development Code, Section 61128A, that is community residential homes housing 6 or fewer residents shall not be located within a radius of 1,000 feet or another such existing home with 6 or fewer residents. And that will be my presentation. Thank you.
All right, thank you. No questions for you. Applicant?
Hi, good morning. My name is Gerard Thomas Doris III. I am provider for adults with disabilities. My address is 1503 Cafe Court, Trinity, Florida, 34655, and I'm requesting this variance due to another residential facility being within 1,000 square feet from this home that I want to open up as an adult with disabilities also.
All right. So variances are based on hardship. Can you discuss the hardship related to this property to support the variance request?
Well, at the time I submitted it, it was right after the hurricanes. So there's been a lot of paperwork that I had to do that I didn't even realize that I had to do a variance due to another home being there. We did have some adults with disabilities that was misplaced that are still in temporary homes. And I also have a mom that's here right now. Well, I've been taking care of her son since like 2014, and she wants to be closer. So she offered me a home along with, to be able to accommodate her from driving from where she lives now to all the way to South Tampa. And we also have some guys that's on standby that's waiting for me to open this home.
Okay, so do you own the property now?
No, the mom does.
I see.
Yes.
I'm sorry, looking at your deed. That is the deed that is in the record. So it looks like the property was acquired in 2011 by the current owner.
Yes.
And are you going to acquire the property, or she will continue to own it and you're operating the home?
As a renter, yeah, operating the home, yes, ma'am.
Okay, I see. And how many placed residents will be there?
I'm going to say between 5 and 6. I want to say 5, but between 5 and 6. Yes.
Okay. All right. And okay. I guess I understand your request then. Your variance is for 757 feet, and the result will be this home will be 243 feet from an existing community residential home. Anything further?
No, pretty straightforward.
Do you know what the other community residential home is, its clients?
It's pretty much the same as I operate, and they've been there for years. So, and the mom has had some, talk with them over the years and been no issues, no problems, so.
Okay, and its residents are elder persons?
Adults with disabilities.
Okay.
I think at one time they were kids, but they changed to adults.
Okay.
Yeah.
And yours will be?
Adults, yes.
Okay. All right.
And then we're going to transition her son that's in my current home, that's in South Tampa, to that home.
I see.
Right down the street from.
I see, okay.
Yes.
I understand. All right, anything further you wish to add?
No, that's it.
All right, be sure and sign in with the clerk, please. All right, is there anyone here or online who wishes to speak in support of this application? right, if you wish to speak in support, please come forward. And need your name and address first.
My name is Carmen Abraham. I live at 314 Floral Drive.
All right. Go ahead, please.
Yes, I'm in support because, like Mr. Gerard said, that I have a son, he has autism, and he lives in South Tampa, and sometimes I'm not able to go that far to visit him. I've owned this house since 2011. It was given to me by my mom and my dad. And I've had several tenants that have not been taking care of the property. So I decided that I would like to have my son, which has autism, closer to me. I live right down the street, and I feel that is in the best interest for me and my son. As well, I took it into consideration, the neighborhood, and I know it's a good neighborhood, and I would like to keep it that way. And I don't think that the house would cause any issues for my neighbors.
Okay, so it's your intention then to lease this subject property to the applicant and to have 5 or 6 placed adults with disabilities stay there. Is that correct?
Correct.
Okay. Anything further?
No, that's it.
All right. Thank you, ma'am. Be sure and sign in with the clerk here. All right. Is there anyone else who wishes to speak in support of this application? I do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? Please come forward if you wish to speak in opposition. How many speakers do we have? 2 speakers. 3? We have 3 speakers. All right, please come forward. All right, if there are 3 speakers, you have a little over, let's see, 4 times 3, a little over 4 minutes apiece, 15 minutes total. 5 times 3, 5 minutes apiece.
My name's Megan Spicer, 1132 Dogwood Avenue, Tampa.
And go ahead with your testimony, please.
I'm currently the director for Avacorp, Inc., the group home that is existing on that road. The proposed group home or adult community residential facility is 4 houses away from ours. And one of the main things in this licensing, you have to go through ACA as well as DCF as well as APD to make sure there is no other facility within 1,000 feet. Because the whole point of that was to keep from having a bunch of disabled houses in the same community, same neighborhood. What's the word I'm thinking of? And it's just make inclusivity, just so that way they feel like they're in their own neighborhood, their own home, without having, unfortunately, I know it sounds weird, but other disabled people right next to them. Because the whole point is they want to feel like they belong in the community as well. That's all I have.
Okay. Then, ma'am, sign in with the clerk here, please. Yes, ma'am.
My name is Ann Vaccaro. I am the owner of Avacor. And first of all, I've never
Can I get your address, please?
And the people, they said that.
Your address too, please.
15810 Fenton Place, Tampa 33618. I have 4 group homes. One of them is at 313 Floral Drive. It's been there for 10 years. Every time you get I've been doing this since 2005. I've been doing this for 20 years. Every time you look for a residential facility in the neighborhood, you must obey all the rules and regulations from not only ACA and APD, but from the fire marshal. It's always been 1,000 to 1,100 square feet. There's been plenty of opportunities where somebody wanted to sell me a house right next door and everything. You can't do it because it's against the rules and regulations. And as far as doing it just to place your child in there, that's why you have a referral system with the Agency of Persons with Disabilities. You can't just say, I want little Johnny to go to this house, let's make a house there for him. It doesn't work like that. If you're going to be getting paid from Medicaid and from ACA and everything, you have to obey the rules and regulations, which I have done for over 20 years. According to 65G-2, that's our house rule regulations to open up a group home in the state of Florida in Hillsborough County.
Okay, where did you get 65G-2? What is that?
I'm sorry.
Is that the Florida Administrative Code?
Yes, for Hillsborough County to APD. for agencies with persons with disabilities. It's the rules to open up a group home and what they expect, and one of which is the 1,000 to 1,100 square feet variance from the fire marshal. It has to get approved from it.
Okay, so that's a state regulation?
Yes.
Okay, thank
And
you.
also 419.01, Florida State 419.01 is community residential housing, and that also shows you have to have 1,000 to 1,100 square feet between homes, so that you don't have several, like 4 or 5 community residential homes within one area, because then you're not affording the clients to live in a diverse community that they don't want to make. They don't want to make like an institutional residential facility around it.
Okay.
They're doing it just so that they have their own inclusivity and that they can live anywhere they want, that they're not just put into a neighborhood known for that.
All right.
And this is what we've been going by for, like what I've been going by since 2005. Again, I'm a state provider with the Agency with Persons with Disability. I'm a Medicaid waiver provider with ACA.
All right.
And I'd really like for you to really consider this, because I was just very, very shocked when I got the letter. I guess I had to get a letter because I'm the only other house, which is four houses away. And again, I've never met the people behind me. No one's ever talked to me or whatnot. So I would really like you to consider just the rules and regulations that everybody that's opened up a group home in Hillsborough County has had to go through.
All right, thank you.
Thank you.
Thank you. All right, next speaker, please.
Hello, my name is Brooke Freeman. My address is 301 Floral Drive. I am located directly next to the property in question. I am the homeowner there. I also found out about this via letter, even though she lives down the street from me and has knocked on my door before. The property next to us has been rented previously to tenants, and we've never had problems with that. It has also been attempted to be sold at least twice since I moved in 2017. We already have a very small street. If one person parks in the street, it's very hard for cars to get around. This is a 2-car driveway. Just in traffic alone, if they have someone there working on it while tenants were living there, they would end up parking in my yard because there's nowhere else to go. In the amount of providers that have to come in for something like this, deliveries, I think that it would be an extreme hardship on me as a property owner literally next door. And I have also spoken to my neighbors on the other side, 121 Floral Drive and also 305 Floral Drive, and they also don't want this. And I know another one of my neighbors submitted comments, which I have here, but she said that she submitted them to the record. Would I need to show those, or would they already be included?
If she submitted them, they will be in the record, but I don't know that she did. You're welcome to leave that with the clerk.
Okay.
And I will see it.
Yeah, she left me a copy because she wanted to make sure it was seen.
Okay.
In addition, the mom of the disabled autistic son in question does live down the street in a rather large home. I think there's plenty of room where her son could live with her if being close was really necessary. Like I said, she's tried to sell the house at least twice. She's rented it to tenants. Her last tenants, who I spoke with, said that she ended their lease because she wanted to sell the house. So I was very surprised when I saw the hearing go up. That's all I have.
All right, thank you. Be sure and sign in with the clerk, and you can submit any evidence you wish to for the record. All right, is that all the speakers in opposition then? Do we still have time on the clerk? Do we still have? We do. All right, come forward, please, and state your name first.
My name is Megan Spicer. In reference to the parking can definitely be an issue, and the road is very small. Like, we have made accommodated on our property where we can use part of our front yard as parking, but typically you have at least 2 staff that are at the house at all times. That's 2 vehicles plus typically a company vehicle that would be there, just in parking alone on a daily basis. So we are lucky on our particular lot. We're on a curve, so we have a little bit of freedom, but the rest of the road is very narrow. There was somebody cutting a tree down this week, and you couldn't get around. You had to literally turn around and back out to go out the other way. So that's all.
All right, thank you. Okay, development services. Anything further?
Nothing further.
Okay. And just one of the speakers mentioned several numbers that she said were rules and regulations. To your knowledge, if staff heard those, were those from the Land Development Code? Any of them?
No, I believe they were all from Florida statutes.
Okay, thank you. Anything, Ms. Dorman, did you have something for me?
Madam Hearing Officer, I just stated that it's possible that it's from the Florida Administrative Code.
And I'll take a look at that too, thank you. All right, we'll go back to the applicant then.
Hi, my name is Gerard Thomas Doris III. Once again, my address is 15303 Capitol Court, Trinity, Florida. I would just like to respond to some of the things. Like I said, I submitted this during the hurricane time when we lost, and a lot of people was misplaced or whatever. So that's why they had laxed some of the, as far as codes, I guess you would say, at that time or whatever. Another thing, we're in the neighborhood, we're planet Earth. I mean, people come in, people leave or whatever. My particular home, we have 1 or 2 staff at all times. This isn't IB home, so we won't be requiring 3 or 4 staff or 3 or 4 cars or anything. But I mean, there's nothing different from somebody else having 3 or 4 family members and they got 3 or 4 cars next door. And also, again, these guys deserve to live, you know, in certain neighborhoods too. Now, again, it is, you know, right down the street from another facility. It's not odd. Like where I have my other group home, there is a home that's like right, you know, not in the same U shape, but right on the next street, right at the front. And we see them all the time, and there's no issues, there's no problems. So I really don't.
Okay, just a couple of questions then.
Yeah, go ahead.
For this particular subject property and your proposed use of it, would you have 1 or 2 staff members there at all times? Is that correct?
1 or 2
staff.
Overnight, 1. Overnight, 1. Depending on if they have a day program or a daily activity, and it also depends on the, you know, the level of the guys. Based on this, you know, her son is pretty much moderate, so I can have 1 staff per 3 guys there. So it just depends on, you know, how many guys are there, really.
Guys, you mean the residents?
Residents, I'm sorry, yeah.
I understand,
Yeah.
thank you. So would this proposed use be comparable to your other, you said you operate other homes?
Yes.
So in your experience, in your other homes then, that I understand would be comparable, how much parking do you need?
How much parking? We have a company vehicle and my car and maybe another staff. So I'm not sure if we can increase the parking or paver or make some more paved so we can put another car there so it's not on the street. It is a small street, so it is a small street. But she said that we can increase the parking by making some more paver, so in the driveway, so you can fit 2 cars there and not be on the street.
Okay, so potentially there would be 3 vehicles there.
3 vehicles, yeah. 2 to 3 vehicles, yeah.
Okay. And how much in and out traffic do you usually experience at your other homes?
So I have an oversight that may come once every other month. She pretty much does my behavior services. I'm behavior analyst. She comes like once every other month. The support coordinators, depending on how many they have. If they have, like, I have 2 in my current home. They come once every other month. And of course, the parents that come to see their guys.
Okay.
So. But a lot of them just pick them up and they go home. But she's probably the only one that actually comes there and sits there. But the other ones kind of like pick them up and then take them home. They don't sit there. So
okay.
That's maybe once or twice a month.
All right. Anything further?
No, ma'am.
All right. All right, thank you, sir.
No problem.
No more questions for you. So this will close the hearing on variance 25-0771.
This brings us to Section I, Special Uses. Item I-1, Special Use 250668. The applicant is Greencoat Market LLC. The request is a Special Use 2 APS alcoholic beverage permit with distance separation waivers. James Baker will provide staff findings after presentation by the applicant.
All right.
Hi, can you
The
hear me?
applicant, are you here? Yes, I can see
I'm
you.
here.
Go ahead and state your name and address first, please.
Hi, my name is Dixie Liberty. I'm at 200 Adams Avenue, Hopkinsville, Kentucky, 42240.
All right, thank you. Go ahead.
Hi, yes, I'm here for Green Goat Market LLC. He is requesting a 2 APS for package sales or retail market, for a retail market. The total wet zoning area is 6996.89 square feet. His address is 2902 South 78th Street. Folio number 47584.0000. Requesting for a waiver. Within the 500 feet, there is a home away from home learning center. The distant waiver is 320 and requesting separation 180. The proposed wet zoning does not include an outdoor seating. There is significant buffering and screening between the subject's property and the child care facility, detention pond, and a 6-foot high fence. The driving distance for the retail market to the child care facility is over 500 feet. That's given the right as access point and right in and right out access point to the retail market. Therefore, to drive from the retail market to the child care facility, a vehicle must make a right turn out of the subject property onto the Causeway Boulevard, make a U-turn, followed by the left onto 78th Street, then would be able to turn left into the child care facility property. It's over 500 feet. The hours for the sale of alcohol beverages, Monday through Saturday, 7 a.m. to 3 a.m. Of the following day, 11 a.m. to 3 a.m. the following day on Sunday. We agreed the limit of the sale of alcohol beverages to Monday through Saturday, 7 a.m. to 9, and Sunday, 11 to 8. There will be no alcohol beverages sold through the drive-through window. And I believe, and then I haven't heard from anybody, but I did speak to the child care center behind them to the south. I spoke to Ms. Carter, and she told me that she is fine with everything. She has no issues.
All right, thank you. No questions for you. County Development County Development Services.
James Baker Development Services, SUAB 25-0668. Pursuant to Land Development Code Section 6.11.11E3, the request is for a distance separation waiver.
Yeah, Mr. Baker, pull the microphone up to you a little bit, please. Thank you.
Pursuant to Land Development Code Section 6.11.11.E3, the request is for a distance separation waiver for a 2 APS alcohol beverage development permit AB for the sale of beer and wine sold in sealed containers only for consumption off the licensed premises. The applicants request a distance separation waiver to a community use child care facility for a 2 APS alcohol beverage permit. The applicant's justification for the waiver includes the following. The driving distance is over 500 feet. The establishment is in an industrial area on a major causeway boulevard. Customers enter the establishment on 78th Street and exit on Causeway Boulevard. The driving distance from the market to the daycare is over 500 feet, given that a driver going from the market to the daycare must exit on Causeway and proceed to the turnaround at the stoplight and proceed southbound on 78 past the daycare and make a U-turn to the daycare. That's all I have.
All right, sir, thank you. No questions for you. All right. Is there anyone here or online who wishes to speak in support of this application? I do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, I do not hear anyone. County Development Services, anything further?
Nothing further, thank you.
All right. And applicant, anything further?
No, ma'am. You have a good day.
All right, thank you. So this closes the hearing on special use AB 25-0668, and this concludes the Land Use Hearing Officer meeting for today.